Let's do the Gavin Newsom, that jackass who parades around. I think it was a late night talk show where he's like, yeah, this is how easy it is to govern. I just sign a bill here, sign a bill there, and implement a wildly what is the word I'm looking for? Facially, is that the word? Facially, I'm sorry, facially unconstitutional law go into effect where he's going to outlaw AI generated memery that has the purpose of influencing elections, whatever the hell. Bottom line, I don't know who the plaintiff was that took it to court and already got an injunction enjoining application of that law, which they said is, I don't know, prima facie on its face unconstitutional. They did not implement the least restrictive means possible in order to address the problem. You'll all remember it's Gavin Newsom saying, look, when Elon Musk retweeted that obvious parody troll video of Kamala Harris explaining why she's the ultimate DEI hire. So if you criticize her, you're both a racist and a misogynist. And then Gavin Newsom says, I'm going to pass a law to make this illegal. And then, I don't know, 2 months later, puts out a bill that outlaws AI-generated memery. And it's been taken to court and already enjoined from application on the basis of superficial, facial level analysis, unconstitutionality. Do you know who the plaintiff was in that case? I'm not familiar with the plaintiff.
Yeah, Coles. I think maybe goes by Mr. Reagan. I forget his Twitter handle. But yeah, filed suit pointing out the things that we pointed out, that the law was likely to get enjoined pretty quickly unless it got just all crazy judges. And it didn't. And the court, it did immediately enjoin the law because it pointed out the state doesn't get to be the arbiter of truth, that the terms were very subjective and vague, that the word harmful, what the heck fire does that mean? That's always been the social media catch-all favorite. Call it harmful and we can regulate it. And the court was like, no, you don't just get to call it harmful. And in this capacity, I mean, noted that, satire has always been constitutionally protected. Parody has always been constitutionally protected. But went a step further. Now it just made it clear the state cannot be the arbiter of truth, but that protecting election information is not a compelling interest in most cases. And to the degree it is, it's got to be very narrowly tailored. It can't be something like this. And the court was skeptical that it even meets. Like, look, we already have a bunch of tort law and statutes on the books to defend reputational harm, to defend a certain interest in privacy, a certain interest in your business model, like copyright laws, etc. Interest in truth in election outcomes is not really a state interest. And if we started calling it a state interest, then that would be very dangerous and precarious for First Amendment liberties and rights. And in this capacity, in part corrected the mistake Tim Walz made during the vice presidential debate, which is where Walz said you can't yell fire in a crowded theater. Yes, you can. And that decision came from a horrendous decision issued during World War I by Justice Holmes, who himself regretted it 3 years later. Because what it was is he is, like most judges, complicit in suppressing people's civil liberties during an emergency. So if it's a public health emergency or war, judges are snoozing when it comes to liberties and rights. Ultimately, they would undermine that logic of that decision and then completely reverse it. That decision, the law Newsom is relying on, is a law that hasn't existed in America for 60 years, thanks to the old Berkeley free speech movement in part. Where a guy stood up at a Vietnam rally and said, he had LBJ in his sniper rifle. And he was charged with threatening the president, and the Supreme Court said you can't do that. That's speech. But they try to use this, by the way, for courts to try to control lawyer speech or advocate speech. They're using standards that have been thrown out by the Supreme Court for 60 years. The standard is not fire in a crowded theater. The standard instead is you have to intend, and the nature of the statements and circumstances be such that you are likely to incite imminent lawless action. So you have to intend imminent lawless action. You have to, in fact, incite it. It has to be likely that you will incite it imminently. Otherwise, it's completely protected. So if you yell fire in a crowded theater and you don't intend to incite imminent lawless action, and it's not likely to incite imminent lawless action, then guess what? You can yell fire in a crowded theater under the First Amendment. Walz is wrong, just as Newsom was wrong. And that's why the state of California also lost against X, for trying to compel them to create a censorship index of how good a job were they doing censoring. They're like, you decided to define censoring. That's a content-driven regulation. That's in violation of the First Amendment too.
Well, hold on, but before we even get there, I love that they said you can't scream fire in a crowded theater, and the piece that I was reading is like, well, of course you can if there's a fire, and you still can if no one's going to be brought to panic. And I'm sitting there thinking, yeah, there's 5 people in a massive theater, and one jackass starts screaming fire, and the other 4 are like, there's no fire here. You don't have that restriction on speech. But I wanted to highlight this because it's actually phenomenally impactful, and it actually says, I think, a lot more than anyone would appreciate the first time reading it. The law does not pass constitutional scrutiny. We're at the injunctive level here, so they haven't had a hearing on the merits yet, but this is, a superficial analysis of it. It does not use the least restrictive means available for advancing the state's interest here. As plaintiff persuasively argue, counter speech is a less restrictive alternative to prohibiting videos such as those posted by plaintiff, no matter how offensive or inappropriate anyone might find them. And the bottom line, it's the old expression. The only counter to hate speech is more speech. And that judgment says it, which I thought was phenomenal to read.